What can an investor do to kind of get ahead of things?
At the origination of the loan, they should have had the person fill out some type of family tree of some sort.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Welcome back to The Weekly Friedman, your source, the most essential information in the default industry. Today, I am joined by foreclosure legend, senior trial attorney, John Ricciardi. John, how's it going?
Hello, everybody. How are you?
John, everyone's been very excited to get you on here.
I'm very excited to be here.
Tell our audience, why is surrogates not boring?
Surrogates isn't boring because it's a necessary part to help the clients proceed with the foreclosure action. When someone's passed away, there's a legal maxim that is the most overstated legal maxim in the world, which is the dead cannot be sued. What they really mean is you just can't sue the estate of John Doe. There has to be someone appointed to that estate, whether they die with or without a will. Very simple concept, but very, very difficult in practice. I've been doing it for quite a while, and everywhere I go, I seem to have the surrogates matters because I take it seriously. And it's not something you kind of put on the back burner. They're difficult, they're tedious, but it has to be done because every month taxes accrue, insurance accrues, the interest is accruing, and the client's not getting any revenue out of the property because the person's dead. Everything stayed until a representative is appointed.
What do you mean back burner, though?
Because I've seen surrogates files while I'm here that I've done in firms 7 years ago that are still open. That's what I mean by back burner.
And so you're seeing it was started at a different firm and it just
And I was the one that did the paperwork on it.
and it just sits, and then you left, and then no one keeps it moving.
Yep, and it's very difficult to keep moving in surrogates court because it's a very archaic set of laws with clerks that can be helpful, particular, or difficult, depending on the county, and some are just obstructionist. So you really have to put the time and effort into it. And they're not the most glamorous cases in the firm. The work you have to do is very factual. It's not like foreclosures where you know you're going to have a note and a mortgage and a default and some notices. This is you're dealing with family histories from a party who is our client, the creditor, who has no idea about who's married to who's dead, who's alive, how many children you have, aunts, uncles, fathers, things of that nature, grandfathers. It runs the gamut with regard to the family history. So you're trying to understand this, and it's very factual and intensive. So while the procedure may be somewhat simple, the actual practice is very difficult.
It's interesting you said that it takes so long, because I think when someone hears about a New York foreclosure matter, right, they assume that it's taking so long because the courts are attempting to assist the borrower, and that's the motivation, and that's the reality of why it slows down. But in a surrogates proceeding, you would think that the courts would want to move quickly.
That's true, but I think a fast turnaround time for a document submission in the surrogates court is 2 months, and some counties are up to a year for a turnaround. So if you submit it, it takes a year for them to get back to you.
So when you say you're really pushing the timeline, right, like what do you do? Like what's a way to keep the timeline moving in surrogates?
I try to send emails because before you could go to the clerks, and you still can, go to the clerks, ask them, introduce yourself to them, make them put a name to the face, which is helpful, and ask them, what's going on with this file, what's going on with that file. You could do that. And now you can also email them. So I email them somewhat regularly what's going on with this. Now, if they tell me they have X amount of lag time, I try not to bother them too much. Some are more responsive than others, but at least you try. And that's all you can do is try to move it along.
How does this vary across the state? Are there certain counties where surrogates is especially difficult?
Yes, there are.
Where is it most complicated?
The most difficult county that I've come across is Richmond County.
And what's a timeline there, start to finish in Richmond?
I would say over 3 years. Extremely difficult. Queens is a long timeline as well. I think because they have a lot more volume, much bigger county. They're very particular, but they're not difficult. There's a difference. They have their rules they have to go by. If you don't do that, they'll let you know and you can correct it relatively quickly. And that's another thing with the surrogates courts is the rules are very archaic. And I've had things that need to be resubmitted because I put a comma instead of the word or. And another bizarre part of surrogates court. If you serve one of the heirs, we'll say, at a different address than you list in the petition, you have to make a request to the court to amend the petition. Doesn't happen in Supreme Court. You serve them all over the place. Doesn't matter what you put in the summons of where they live. That's just one of the really archaic rules that can slow things down a little bit.
Typically, when you're looking at a stay or delay, this foreclosure matter is going to be delayed for X period of time. Either it's a bankruptcy, which they understand very well, or it's something like within the action, like we're waiting for an AOM or we have a document problem. In your experience, how do clients perceive surrogates issues?
I think they understand that because someone is deceased, there's a stay that they can't proceed. But they also use their internal notes of probate hold. Well, it's not really a probate hold. It's a surrogate's hold because there's probate and administration, two completely different things.
What's the difference?
So when you pass away, if you have a will, that your estate is testate, means you have a will, and that's a probate proceeding. And that is where an executor is appointed to probate the will. If you die intestate without a will, that's an administration proceeding, and letters of administration are issued to someone, a relative, it doesn't need to be, that would disperse the assets of the estate. The issue that we have and our clients have is that when we get the file, we don't necessarily know if there's a will out there. We could check the surrogate's court records to see, because you could file a will and it'll be on file, so we know. But we've had cases where we file administration proceedings saying there's no will, because that's all we know, and then someone has a will and files a will, and that'll cause more delay, because we're really not the party to probate a will. A will is not self-executing. You have to probate it. It has to be person has to be of sound mind. It has to meet all the requirements. The writing has to meet the requirements. The signature has to meet the requirements. You have to get attesting witnesses, and hopefully no one objects. Whereas an administration proceeding, you don't have to do all that stuff. You just have to find the next of kin, and that's the hardest part in that. A will is easy. It's easy that way because everything's listed out. Problem with wills is people start getting very generous with things that don't affect us, like knickknacks, books, $50 here, $100 to this charity, which we have to name and serve and find in our papers, which makes it extremely difficult.
You know, we're seeing a rise with reverse mortgage foreclosures, and a lot of investors are coming to us with questions in that regard. So if you know that you're purchasing a property where clearly in the reverse, right, the owner is deceased, what can an investor do to kind of get ahead of things?
At the origination of the loan, they should have had the person fill out some type of family tree of some sort, listing, okay, this is who are my children are, my spouse, all this. They can ask, after that, if our clients get the loan, they can ask, send out a family tree affidavit. Here, please prepare this, because that'll give us a head start as to what happens. Do you have a will? Yes, please send us a copy if they can. But that would jumpstart the process, because the longest process is trying to get the names and addresses for all the distributees, fancy word for heirs, named and served. And that's the longest process that we have.
What if we're later, right? So what if we're an investor that has now purchased these from the originator and they know they're going to board in 90 days, right? How do they even start trying to locate people?
What I do is all the social medias, you can run a skip trace, depending how good it is. Some of them will have the alleged relatives. You do a Google search for an obituary. Believe it or not, certain counties, like Richmond County, a lot more people in Richmond County file obituaries than anywhere else for some reason. I don't know why. And then you can hire a company, like a process server, to call, run skip traces, make phone calls, send out these letters asking for family trees, and sometimes they get a response.
Look, John, I really appreciate it. I think things like this, surrogates, right? Some of these things are kind of like around the edges of the foreclosure. I think some firms don't really take them that seriously. And the reality is, like, you can have some complex foreclosures, but the process remains the same for the most part, especially in New York. When you start deviating and have deceased borrowers and you're navigating all these complicated surrogates proceedings, I think it's really important that any firm practicing in this industry is not only competent, but really well-versed in it, because there's a lot of twists and turns. So I appreciate you explaining this. I appreciate what you bring to the firm in this area. I'm glad I finally got to have you on here. I'm sure you'll be back soon.
It was a pleasure. Thank you.
Thanks for tuning in to the Weekly Friedman, your source for the most essential information in the default industry. We appreciate you watching, and we look forward to seeing you next time.